Good evening, everyone, and welcome to a rather informative and productive session where we will be delving deep into a very recent and trending political topic on if Sri Lanka should go beyond the 13th Amendment in power sharing. Now, before we commence the session, I'd like to ask all of you to keep your mics muted and also keep your cameras on so we can maintain an interactive session. Also, there will also be a Q&A session towards the end of this webinar. So be vigilant on that as well. And please do send whatever questions you guys have onto the chats. Okay, without further ado, let me introduce our resource persons for today. Firstly, we have Mr. Ruchira Perera, the Assistant Lecturer in Political Science at the Department of Public Policy in the University of Ruhuna. Mr. Ruchira has also obtained an MA in the University of Kelaniya and a BA in Kelaniya as well. Secondly, we have Mr. Gimhan Suryabandara, Attorney at Law, LLB, University of Colombo, MA in Political Science at the University of Kelaniya, author, activist, and a renowned tutor in political science. Thirdly, we have Ms. Chiranthi Senanayake, an attorney at law, development justice and development governance researcher, and she is also a lecturer. Without further ado, let us now get into the crux of today's topic. Now, something very clear that we've understood under Article 2 of Sri Lanka's constitution is that Sri Lanka is essentially what we would call a unitary state. However, we observe that countries like America is essentially federal in nature. And I'd like to pose this question to Mr. Gimhan Suryabandara, if you would please to answer. What is the basic difference between a unitary and federal system, sir?
Right. First of all, thank you very much, Melinda, for that introduction. And thank you very much for IDMNC and Bucks University for giving me this opportunity. Now, to begin with this session, so I'm planning on providing you the foundation by giving you the basic idea of unitary and federal. So my fellow panelists will take it further from there and get into the advanced areas of this topic. So to begin with, what is unitary and federal? Now, imagine a family where parents are in full authority of the children, where the children have to act exactly how the parents tell them to. Or imagine a house with somewhat grown-up adult children where parents are having their role and the children are given some sort of an independence to live their lives and parents not getting involved. This is the basic, the simplest way of looking at a unitary country and a federal country, right? So in a unitary country, you have the central government having full authority and full sovereignty and full dominance over the regional governments, similar to a family where parents have full authority over the children, whereas the children have to seek permission from the parents before doing something. Whereas the federal country, in the simplest format, is like a family where the parents are there with adult children who are grown, who have their own independent lives. So parents handle their responsibilities and children live their lives, and they both respect each other's independence and each other's autonomy. They don't get involved in each other's decision making. That's the simplest way of putting it down for an absolute beginner who have no idea about the words unitary or federal. To get a little more detailed, for someone who's coming from a law background or a political science background to understand, if you look at a certain country, or in today's context we call them nation states, a nation or a state, this always has something called sovereign power, the absolute authority. That's what makes the states unique. So when you take states into consideration, they have a power called sovereign power. That's the supreme authority the state has. When it comes to a unitary country, the central government of the country keeps all that authority to themselves. Then secondly, if it's a federal country, the central government and the regional government share these sovereign powers. They sort of share a level of sovereignty. Central government is sovereign in their area, regional governments are sovereign in their area. They both respect each other's sovereign authority. To put it into another perspective, when it comes to a federal country, you see that when it comes to any country for that matter, there are different layers of governance. You have a national level of governance. For example, in Sri Lanka, we have a president and a parliament, right? That is the national level of governance. National layer of government. You call it the central government because it's not geographically in the center, but of course it's the political structure that is the core of the government, right? And secondly, you have the regional layer of government. Sri Lanka, we have provincial councils. That's a government for a particular region. Then you have the grassroots layer of government, the local government authorities, the municipal councils, urban councils, and Pradesh Sabha or divisional councils, which are handling like the grassroots level activities. Now it's a matter of who actually has the authority, because if it's a unitary country, the entire political authority is with the central government. Central government makes sure that they only allow the regional governments and local government authorities to function under certain restrictions. Whereas in federal countries, those regional governments have an independence to make decisions. In simple words, I will take Sri Lanka. We will study about how Sri Lanka is unitary or federal, whatever that has. We move forward in this session. But of course, Sri Lanka is recognized as a unitary country, as our host Milinda also put himself as, according to the first page of the constitution itself. So we have provincial councils in Sri Lanka. In simple words, the chief minister of a province is not allowed to do something without our parliament and the president not being aware of it or not necessarily authorizing that action. It's a little complicated than that, but let's put it that way so it's easier to understand. But in USA, the governor of Texas can make a decision for Texas. The governor of New York can make a decision for New York. The governor of California can make a decision for California. Without necessarily running it by President Joe Biden and the US Congress. You don't have to ask from Washington, D.C., and you can make a decision in your area. That's what we mean by a regional government having a certain level of independence. Now, of course, there are exceptions, of course, comes under this. When I say like permission, it's not always permission. Of course, we'll get into that. I believe Ruchira and Chiranthi will explain this further. The basic idea is that you have an independency up to a reasonable extent now. But there are restrictions, of course, now just because you are a federal country doesn't mean the state is allowed to have their own army, right? So there are certain restrictions, there are certain powers only the central government has. And also there are certain exceptions because when it comes to federal countries, different countries have different applications. For example, now you take USA and Canada. USA has a version which is more favorable towards the state. The regional governments are much powerful. Canada, compared to USA, Canadian regional governments aren't that powerful compared to USA. And you have countries like India, where central government has somewhat of an authority, that independence that they've given to the regional governments could be reverted back to the central government anytime. So much so that in political science, we even refer to India as a semi-federal country rather than not even a fully federal country. So there are different versions. However, the most important part is that the simplest explanation that we can give is that in unitary countries, either there are no regional governments or whatever the regional governments you have are functioning under certain restrictions. And in federal countries, the regional governments function with an independency, a reasonable independency, unless it is something that gets in the way of the national interest of the country, the regions are allowed to function on their own. So there's a misconception that goes around. Unfortunately, some professionals also use this misconception, this inaccurate version. Some professionals refer to it as like, if there are no regional governments, it is unitary. If there are regional governments existing, that is federal. That is not a correct way of referring to that. Point is that the mere existence of a regional government doesn't make a country federal. It's a matter of whether that regional government is independent or not, right? So unitary means either you don't have regional governments or you do have regional governments, but they are functioning under the control of the central government. Federal means the regional governments are functioning under the independency that they've got from the central government because they are sharing the power. But of course, given that certain countries, unitary countries, can use certain mechanisms like deconcentration, devolution, decentralization, and all of that. Even in Sri Lanka, we have used devolution of powers, just like in UK. So I believe my other panelists will further explain those. And I hope that my explanation of the basic difference between unitary and federal was clear enough. So over to you, Mr.
But just like you said, Mr. Surya Bandara, now eventually a completely restricted system where the central government takes almost complete authority within that sovereign nation. We've understood that over time, this system has changed substantially. This is where you also mentioned the advancement of concepts like devolution and decentralization. With that, Ms. Chiranthi Senanayake, I hope you could answer this question. What is devolution of powers in and of itself, especially when we consider its application in a unitary system like Sri Lanka?
Firstly, thank you so much, Melinda, for having me and for Kimhan for inviting me as well. It's such a pleasure to be here. I hope I can be heard clearly and seen clearly as well. Okay, fantastic. So before venturing into the answer itself, I just wanted to sort of make a disclaimer because I think there might be a very diverse audience present today. So when speaking about the 13th Amendment or the 13 plus process, unfortunately, the entire conversation has become a very sensitive topic considering the very ethno-national dimensions of the topic. And hence, I just wanted to highlight that I'm sure the other resource persons will also agree with me that this is intended to be a very rational and perhaps a learned conversation of the topic, and in no way is it intended to sort of marginalize a particular community or represent the views of one community only. And I just wanted to clarify that in case there was a concern of such sorts. So now that has been clarified, I just wanted to actually go straight to answering the question. I think I can actually just expand upon what Kimhan perfectly captured in terms of defining a unitary state. But firstly, I wanted to highlight that if you take a look at this concept of concentrating power into one entity, which is called the monopolization of state power, and if you look at the absence of effective checks and balances, both those qualities are now globally frowned upon as not being democratic. So we see that democracy is technically adopted as the so-called approach to governance across the world. And considering the fact that Sri Lanka's 78 constitution recognizes Sri Lanka as a democratic socialist republic, there is understanding that Sri Lanka's governance structure is intended to be democratic. So therefore, like demonopolizing or perhaps like deconcentrating, breaking down power and trying to assign it to different entities so that there is effective balance of power and power isn't concentrated, it's separated, that is considered to be a quality that is sought after by a democratic state. So I just wanted to mention that because it's an aspiration that technically countries are supposed to go towards. But having said that, I wanted to sort of clarify something, which is basically the fact that a lot of us, including very learned political science analysts, we tend to interchangeably use the word devolve and decentralize. And they're entirely different aspects, different processes. And why I wanted to highlight that is because in a unitary state, you technically can't devolve power. You can decentralize power. And when you say that there is devolution in a unitary state, that's actually a conundrum. It's a paradox because it can't happen. Let me tell you why that is. So according to the very I would say post-World War II understanding of what a state is composed of like 3 branches, right? And I'm sure you would have heard it anywhere. Even if you didn't like study law or political science. So you have the 3 main branches, that's the judiciary, the executive, and the legislature. So we know that the judiciary is the arm that's in charge of the interpretation and it's mainly the interpretation of the law. And then you have the legislature that forms the law, and you have the executive that is the topmost entity in charge of the administration of the country. So if you basically, most of the time in any country, in most countries, even in federal countries, you have a central government that oversees these 3 main functions. But where you actually give away legislative and judiciary functions, or where you delegate legislative and judiciary functions to lower level governance authorities like provincial councils, district councils, etc., then that is called devolution. So you're giving away judicial as well as legislative powers. Versus decentralization is a process where you delegate administrative authorities. You actually make the task easier, but the central government remains the apex authority and it remains the most highest reporting authority. So I wanted to clarify that these two concepts are entirely different. So if you are to remain a unitary state, you technically cannot devolve power, you can decentralize power. So by that characteristic itself, Sri Lanka is a unitary state on the basis that provincial councils mainly handle administrative functions. Now, for example, there is a lot of debate about whether or not provincial councils in Sri Lanka should be vested with police authority and to what extent it should be vested with police authority. So why the debate is so controversial is because if by any chance any law-making authority and law enforcement authority is completely let go to the provincial councils, then we see that there is a devolution of power and it infringes upon Sri Lanka's so-called unitary status. So I'll just give across a couple of definitions of what a unitary state is, just to add to what Gilman said. So we have this really if any of you are law students, I'm sure you would have come across this name called Dicey. He defined what the rule of law is. So Dicey basically says that a unitary state is technically any entity that has one central authority, right, which really implements the law. And then you have another famous political professor called C.S. Strong, and he says that a state can be considered unitary if you don't have extra sovereign bodies apart from the central government who actually handles power. But if you take a look at the literature that's out there, personally, I believe that there are four main qualities of unitary state, and Sri Lanka actually fulfills those qualities. The first is the fact that the parliament is the legislature. It's the topmost lawmaking body. And secondly, we see that there is a decentralization of administrative powers by the 13th Amendment. I mean, we can all agree that it is not done effectively, and it has now been converted into a separatist conversation rather than a political conversation. And the third is the fact that there is a centralization of sovereign power on the central government. And then the fourth is that the legislative and the judicial functions still remain with the central government. So that's why I wanted to sort of clarify that technically in unitary states, there is no devolution, there is only decentralization. Thank you.
Ms. Senanayake. Very interesting actually on how you broke down what devolution and decentralization, because I think there is a bit of a misconception when we apply those two terms in a unitary state. On that note, when we talk about decentralization in Sri Lanka, you also mentioned this, that we have the 13th Amendment, and we saw provincial councils coming into play, something that was not essentially expected within the conventional course of our constitution in the start. So I'd like to pose this question to Mr. Ruchira Perera. Mr. Perera, now the history of power sharing in Sri Lanka and the political background of the Indo-Sri Lankan Peace Pact. Would you give us a little bit more insight, essentially, on the historical overview and the development of how this provincial council system really came into play in our country?
Thank you, Mahendra. So now speaking about this provincial councils in Sri Lanka and the centralization of powers, firstly, we need to look at the historical background, obviously. Now, if we go back to history, there is a great debate about whether Sri Lanka was a unitary state or we have some sort of a decentralization, or otherwise we were a federal system. Because if you go back to early days, there is sort of a three separate divisions as Ruhunu, Pihiti, and Maya. And even in the days prior to King Dutugamunu, there was another ruler in the down south who is ruling the country, while Elara was ruling the north, or basically Anuradhapura Kingdom. So there are kind of arguments and disagreements regarding whether historically Sri Lanka was a unitary state or it is sort of a federal system. Anyhow, if we come back to this situation, I would like to go to the days where the universal franchise has been granted to Sri Lanka in 1931. Now, if you look at the outlook, universal franchise, yeah, it's a good thing. It must be implemented. Sri Lanka, I think, was the first country in Asia to obtain universal franchise due to one reason, and that is we were governed by the British monarch. So in Britain, due to there are some obvious reasons. One key reason was that there was a feminist wave happened in 1927, where most of women requested the political rights, and there onwards, British also decided to give them the universal franchise, and it came to Sri Lanka in 1931. When this was implemented, there were certain discussions among various social groups, ethnic groups, whether regarding the applicability of universal franchise, because of course Sri Lanka is a country where you have a Sinhalese majority. In universal franchise, what will happen is the decisions will be taken by the will of majority. That is how the representative democracy will function. So there were certain kind of contrasting arguments whether the universal franchise should be implemented to Sri Lanka. However, when this was in practice for a few years, the British ruler realized that there can be kind of uprising of ethnic tension in Sri Lanka because of this Sinhalese majority government or whatever it is. And that is why they have decided to grant us, they have decided that the Salisbury Constitution should contain special provisions to safeguard the rights of minority. As you all know, the Article 29 subsection 2 mentions about various factors, various limitations when it comes to lawmaking, right? One might argue that it has become a constitutional deadlock because we could not amend the constitution, and that is why the constitutional revolution took place in 1970 to introduce a new constitution to Sri Lanka. However, I believe that the framers of Salisbury realized that there is a tendency of ethnic tension, and we need to provide separate provisions which protects the rights of minority, as in the Salisbury Constitution, not only the 29 subsection 2, as you know, it's a bicameral legislature, and there were independent commissions, and the delimitation process was specifically also focused about providing equal representation for all of ethnicities, and it went on. But unfortunately, as we all know, one of the main reasons that actually triggered this some sort of ethnic tension is the National Language Act. I'm not saying that National Language Act is totally a bad thing. There are positives as well as negatives as well. Now, we all know about the Education Act of 1943. But it became sort of a realization with the National Language Act, because that is how the ordinary people in rural areas, in marginalized areas, able to study in Sinhala medium and qualify into university and get into their higher education. But however, with this National Language Act of 1958, most of our administration mechanism began to function through the Sinhala language. So it had created some sort of I could not say grievances exactly, but some sort of issues among the other ethnicities where their language is not Sinhalese. Other than that, if we move on, this main then of course these organizations like the LTTE came on to operation from 1975, but this civil war mainly triggered into an extent of a civil war in 1982 with the 1983 with the Black July incident, and that is where most of other ethnicities felt that there is sort of a marginalization of non-Sinhalese community. So then the war went on, and there was a situation where this is known as Mission Vadamarachi. It was some sort of a crucial point in the Sri Lankan Civil War. And at that point of time, Indian forces decided to innovate to Sri Lanka. They have conquered the airfield of Sri Lanka, and that at that point of time, Sri Lankan forces had to step back, and the government decided to hold the war. And then only this, the famous J.R. Rajiv peace accord happened in 1987. So there are a few conditions in that peace accord. It had mentioned that this decentralization. Now in here there is an argument whether what is the most applicable term, whether it is devolution or decentralization. So there should be a political solution to this. And secondly, the forces should be taken back. So there are such kind of mentionings in the agreement, and it was signed. Before that, there were a few other agreements made among the Sri Lankan leaders, like the agreement between Bandaranaike and Selvanayagam, Dudley Selvanayagam, which did not became a reality. Right? Leaders signed the agreements, but it did not practically implemented in Sri Lanka. So the government was pressurized to implement this peace accord in 1987. Accordingly, this 13th Amendment was created and included into the Constitution of Sri Lanka at that point of time as a solution for these ethnic issues, to provide some sort of a decentralization of powers and decision-making powers to the provinces in Sri Lanka. So that is how, that is the historical background of the 13th Amendment to the Constitution.
Thank you, Mr. Perera. Just adding on to what you just explained. Now, Mr. Perera, we understand that the Provincial Council, which essentially came through the 13th Amendment, it also introduced very new aspects to our legal system and our governance system in general. For example, the Provincial Council lists, then also the administration itself of the Provincial Council. We know that there is a governor and it has its own separate sort of governing body. Would you be kind enough to explain in more detail exactly how the lists work and how the administration of the Provincial Council itself is practically applied in Sri Lanka?
Now, when this was introduced to Sri Lanka, quickly it was challenged by the opposition, mainly by Mrs. Bandaranaike. They have put up a petition in the Supreme Court that this will change the unitary nature of the Sri Lankan Constitution. It will affect the legislative supremacy of the Parliament, which is mentioned in the Article 76. It says that the Parliament in any manner should not alienate its powers, should not put up any other authority which has the legislative powers. So this has become some sort of an interesting incident, and the judgment is of course interesting because it's not a unanimous decision. As I remember, there are it was a 9-bench judge board which decided, and 4 of them decided that this has some sort of an effect about the unitary nature of Sri Lanka, and 5 of them decided that it will not. So it's a split decision. It's not a unanimous decision. Anyhow, this became into operation in Sri Lanka. And if you look at the mechanism of the 13th Amendment, I hope that most of you are joining in this conversation will have an idea about the Indian semi-federal system. Indian semi-federal system has 3 lists of power sharing, right? They have the powers to the national government, the state government, and the powers that they could activate in collaboration, as well as they have a chief minister to every province and a governor as well. So there are 29 provinces in India. If you look at the framework, the 13th Amendment also has 3 lists: reserved, provincial, and concurrent. Reserved is the list which have reserved power to the central government, provincial list, and the concurrent list, the 3rd one. So in our system as well, we have a chief minister who is appointed, elected by the people of that province, and there is a governor who will be appointed by the president, and governor will work as a representative to the president. So there are various powers which has been allocated to the provincial councils, and there are debates about those powers as well. But however, as this is a decentralization system, the power comes from the central government, which means that the president plus the parliament can make interesting decisions about the provincial councils, about the functionings of the provincial councils. They are not autonomous. And as now, if one could argue that this might challenge the Article 76 of the Constitution, where it has the legislative powers, but it's not, because provincial councils cannot make laws, they can only make statutes, and statutes are only eligible for that provincial council. So, however, president use govern of the council to control the province, and there is an elected, there will be 5 ministers, including the chief minister, right, for every provincial council. So then the other thing that we need to focus, we need to think about whether it is successful in Sri Lanka. Obviously, the main reason to introduce the decentralization is, of course, the Civil War and the Indo-Sri Lanka Peace Accord, as I mentioned. So the North Provincial Council was established in, I think, 2013, and it was in operation for about 5 years. Other than that, previously, these other councils was in operation, but the North Provincial Council was in operation only at that time. So therefore, there is a public discourse whether this delivered the results that were expected. Because today, now we are about many years without provincial councils, right? Because we never know when the elections will be held, and we never know whether the local government election will be held in this year or next year. What election, what kind of election will arrive next? So there is a public discourse, and we need to be sensitive about that as well, about the applicability of the provincial councils, or do we need to implement another system? And there are certain statements made earlier as well. So now our topic is, of course, 13+. Now I could remember this happened actually after the Civil War concluded in Sri Lanka. The foreign minister, I think it was Mr. G.L. Peris, who mentioned such kind of a statement, I'm not sure. Someone from that government said that we are going to go beyond 13. So we need to have, and there are various kind of myths which has been delivered when this system came into operation. Now, some say that if we fully implemented the 13th Amendment, now these are totally myths, right? You need to obtain visa when you go through provinces. Actually, it had to be ridiculous, right? Because not even in the European Union you need to get visa. So there are such kind of false statements which has been spread around the public by various extremist groups. So this is the mechanism of the provincial councils system in Sri Lanka, and there are 3 lists which are mentioned in the Constitution. And in the Constitution, this Article 154 is the largest article in the Constitution, which explains about the functionings of the provincial council. So before implementation of the 13th Amendment, it will be much more smaller document. So therefore, I'm not going to go into every article in detail and what it says from in the 154A, 154B, 154C, and it goes along with the alphabetical order. So this is the basic functioning mechanism of the provincial council system that is introduced to Sri Lanka.
To the whole bench. So Mr. Ruchira Perera and Ms. Chiranthi, if you would like to answer this together also, it's fine. So now we understand that the entire concept that we're discussing here today and the application of provincial councils itself, it's rather unsure. The true intention of a provincial council in Sri Lanka and its practicality has come into question a lot within modern time, within today's world. So the question I want to ask is, what are the weaknesses of the 13th Amendment? And do we need to go beyond the 13th Amendment when power sharing in Sri Lanka, considering certain factors that we've already discussed, such as the fact that Sri Lanka is not federal, but rather unitary. Then Sri Lanka is also practicing essentially a system of decentralization rather than what we would conventionally call devolution. So yes, over to the panel.
So before moving on to answering the question, I wanted to actually highlight the political context in which this whole 13 plus conversation really came up recently, because I think it adds a little bit of nuance to why this conversation is important. So in August this year, we actually saw President Ranil Wickremesinghe really, he kind of ignited this parliamentary conversation regarding completely overhauling the provincial council system. And what was discussed was whether the Provincial Council Voting Act should actually be adopted. And the conversation about endorsing the Provincial Council Voting Act was whether or not, one, there should be a district proportional system adopted, and then whether or not members of parliament can really contest in provincial council elections. And there was also a conversation about whether or not there should be like a 25% minimum representation of women in the provincial councils. And it was also discussed that there would be a committee that would be headed to really look at whether or not the Provincial Council Voting Act should be adopted. And we also see that there was another suggestion that was made was whether or not an advisory council should be appointed to guide the current provincial governance system until the entire system, that a new system is in place and we can get the provincial councils up and running again. Because I think Ruchira already mentioned that there is a lot of politics behind the whole provincial council elections not taking place. Right? Now, what's interesting is this conversation in August really followed President Ranil Wickremesinghe's visit to India in July. Just the month before. And in that visit, we actually saw how, Prime Minister Narendra Modi kind of encouraged President Ranil Wickremesinghe to push forward the 13th Amendment and to completely, implement the 13th Amendment. And what was interesting is the words that were actually used with regards to this, right? Where it was said that the 13th Amendment should be implemented to ensure the so-called welfare of the Tamil people. So I wanted to bring in this nuance simply to highlight that even though we debate in a very political sense about the 13th Amendment, there is quite a lot of real life, ethno-national dimensions to it that we need to consider as well. And with that, I think that, I just wanted to add that to the conversation because we need to consider it. And I saw a question also in the Q&A where someone had asked whether the 13th Amendment protects the rights of the minorities. So firstly, I think one big problem that I have with the 13th Amendment, maybe this is a personal reflection, is the fact that the 13th Amendment is a surface level devolution. So you have the structure that suggests that it's a devolution, but in reality, it's actually a decentralization of power, right? And the reason, in my opinion, maybe Ruchira can correct me if I'm wrong, the main reason as to why this so-called surface level structure was appointed is because of the pressure that was exerted by India, the geopolitical pressure that was exerted by India in relation to the 1987 Accord. And we see that there is a mechanism that is in place for devolution through two main acts. So you have the Provincial Councils Act number 42 of 1987, and then you also have the Provincial Councils Consequential Provisions Act of 1989. Now, so you have the mechanism in place for devolution, but technically what has happened is decentralization. So I'll bring in two examples to tell you why that is, right? So the first example is through the 13th Amendment, there were three main commissions that were established. So you have the Finance Commission, you have the Provincial Public Service Commission, then you also have the Provincial Police Service Commission. So technically these commissions should have the power for there to be devolution. But we see they mainly serve very surface level administrative functions. So technically there's only decentralization. And another example I want to bring up is the lawmaking powers of the provincial council. Now, Ruchira already mentioned that provincial councils can't really put forward acts, they can only put forward statutes. And what's interesting is that the governor of the provincial council and the provincial council as a whole can only put forward statutes pertaining to two main lists of the 1978 constitution, right? So you have the provincial council list and then you have the concurrent list. But what we see is that the parliamentary list is entirely reserved for lawmaking of the Sri Lankan parliament. So when you take a look at these lists and what's included in these lists, what we really see is that majority of the inclusions in these two lists are administrative. They technically do not have purviews of independent judicial and legislative decision making. So that, in my opinion, is the biggest weakness of the 13th Amendment as it stands. It has a surface level structure for power devolution, but it's really a decentralization process. And in terms of whether or not we need a 13 plus power sharing, so this is my personal, I would say, humble as well as like, learned opinion, if that is the right way to say it. But of course, I'm learning so much still. I believe that Sri Lanka should remain a unitary state, and there has to be effective decentralization of power. And I think we need greater conversation as to why the 13th Amendment and devolution of power is going to somehow ensure the welfare of the minorities. I feel like that conversation has become synonymous with insurance of welfare of the minorities, because of course there has been gross human rights violations in terms of the welfare of minorities, which we can't ignore historically. But at the same time, I feel like it's an assumption to say that simply the devolution of power and a complete implementation of the 13th Amendment is going to miraculously result in a pro-human rights environment for in Sri Lanka. So that's my take on it.
So a very good explanation about the practicality and the implementation of this 13th Amendment and Provincial Council. So yeah, now if we look deep into this matter, whether this is applicable or what, firstly, we need to implement what is mentioned in the Constitution. If that is introduced in the Constitution, if it is in the Supreme Law, we need to carry out as it is. So I don't think we need to keep the restrictions or whatever. And I'm not so sure that this 13th Amendment is the most applicable mechanism to provide equal rights to ethnicities which are territorially wise located. So we need to think beyond that, and we need to look at, are there any sort of patterns that we can implement? But of course, myself, I will also agree that we need to stay within the unitary nature of Sri Lanka, but within that nature, we can decentralize powers and allow these regions to take decisions as their own wish. And one more thing, this 13th Amendment was actually has been introduced by India because now there's a concept that the laws should be homegrown and laws should address the aspirations of the society. Right now, there's a famous publication done by Charles Montesquieu in 1748, which says the spirits of law. You need to consider the history, the culture, not only that, the climate and weather conditions as well, because Montesquieu says that you need to implement tough laws to control people who are living in a warmer climate, because there is sort of a biological and psychological factor. So however it is, we need to look at our people and what they actually want. And at this point of time, I should mention that there are extremist groups in both the sides. There are political parties or maybe other political movements which they feed each other. Right now, if there is an extremist group in down south, they will feed the extremist group in north, because they need to show something to the people that there is an issue, and this Sinhalese now, if it is in the north, the Sinhalese majority government will take our rights, so we need to stand up against it. And in down south, they will criticize whoever in the north and say that, okay, this political party is going to take your rights and they are going to make the country a federal or maybe a confederation or whatever. So we need to think beyond politics, right? We need to have a rational approach to this. I hope mostly the academics of Sri Lanka and other specialists of this lawmaking should involve in this process. And I personally do not think that the 13th Amendment is the most optimum solution. But to find out whether that is true, we need to implement the 13th Amendment as it is in the Constitution. So currently it has not, because of this political issue that we have, the election has not been kept. We do not know when it will happen. So yes, I also do agree. We have to, it's better to stay in the unitary nature, but within that nature, we can deliver the decentralization of powers and allow the councils to make decisions considering their certain willingnesses and aspirations. And I feel that it will deliver better for the people. And of course, regarding human rights, it will not be enough. We need to strengthen the human rights mechanism in Sri Lanka. If you could strengthen the Human Rights Commission, and of course the fundamental rights chapter of the Constitution can be further strengthened in that order. So there are some other factors that you need to realize. You need to how to say implement to look after rights of minority. And of course, so we need to review this thing with a wider public discourse. But then again, we cannot expect that the public is always rational. When it comes to if you are introducing another amendment to this constitution or another decentralization mechanism, whatever it is, it should be done by the specialist and with having a discourse with the public as well. Because if public is mostly, I mean, Sri Lankan public has sort of an issue. They always chase after populism or popular topics. So if there's a popular argument against decentralization, the public will grab it. So because the public can be manipulated through media and all of other stuff, media, culture, and etc. So that is my view on that. Yes.
I think we actually covered a lot of the questions as well that were posed to us, because I was just reading through the Q&A questions and it's almost, I think it's completely covered. Just this one question that's posed to Mr. Perera by, I think it's Suki. She has asked, what is the difference, I think, between the Provincial Council system and District Development Council? Is there a similarity? That's what Suki has posed to Mr. Perera.
There is a certain difference between that. The thing is that districts, this development committee, what in English we call this Sangvardhana Sabha, it had a different approach to these provincial councils. If you look at this, the mechanism as well, it's different. So I think such kind of a thing will be far more complicated to Sri Lanka, because I think the decentralization will go as far as the provinces, because if we have 9 provinces in Sri Lanka, so if we are going further, further we have the local governments. I feel that this local government system is somewhat okay. I mean, we don't have any debates whether the local governments should be there or not, although the current elections has not been held. I feel that there is a difference, and I feel that we need to create some sort of a mechanism in the provincial level, because we already have the local government system in Sri Lanka.
Is now, I think we are in agreement, I think the entire panel is in agreement that Sri Lanka itself is and should essentially stay a unitary country. But within that framework, should we maintain provincial councils, or is there any use of the 13th Amendment still being here?
Implement the councils at least for 5 years with all of the powers, then we could see, we can take on that. Then we can see whether it can deliver the results or not, because it has not been properly implemented throughout from 1987 up to now. So we have to wait and see what will happen, whether it will deliver. We need to activate 9 councils in Sri Lanka and find out whether it delivers the results. Right. So then onwards, we can take a decision. Okay, if we are looking for a further mechanism, or we are going to introduce another amendment, and then we can take on that.
Thank you so much. I actually have a little bit of a different answer, maybe because I'm worried about the implications of the 13th Amendment being implemented fully. Why I say that is, okay, let's first answer the question as to whether provincial councils are important. So in my opinion, provincial councils as administrative bodies are important simply because only having the central government means that grassroots level local community problems are not heard by central authorities. And considering how bureaucratic Sri Lanka's governance structure already is, the chances of, let's say, someone who has who needs to get the road fixed, or someone who's having, let's say, an issue with regards to their Gram Niladari, the fact that, them having to come all the way to Colombo to, be represented for their grievances to be heard, I feel like the not having the provincial councils makes Sri Lanka a very non-representative, non-inclusive democracy. So as administrative units, provincial councils need to exist. But in terms of whether they should be provided with legislative and judicial powers. So for me, I believe that this is, of course, my personal opinion. I feel like the 13th Amendment to the Constitution as it stands currently, because of the fact that it sets up a mechanism for devolution but only delivers decentralization, means that the amendment itself isn't really fully fledged, right? So I would say that if we are to really go forward with some sort of decentralization of power, we should rethink the entire concept completely and go for something that actually enables decentralization, as opposed to, promising India devolution and then delivering decentralization. Because the issue with, in my opinion, with completely implementing the 13th Amendment is once we implement it, it kind of goes beyond our control on whether we can go back, right? Because there are so many political, when I mean party politics or partisan political factors that are at play. There is, there is enough and more politicians that, just like Ruchira mentioned, who are playing on Sri Lanka's, ethnic tensions. There is enough geopolitical pressure from India. So if you take a look at all these factors, in my opinion, we're better off revisiting the entire system and going for a proper decentralization, as opposed to implementing the 13th Amendment the way it stands. But that's just my personal take on it.
With that, I think we've come to an end of our Q&A session as well. I think we've answered a majority of the opinions viewed here. So I think we can sum up our session for today. It's been a very productive and informative session, I'm sure. I hope the attendees received something useful, especially about our country's provincial council system. Thank you, Mr. Surya Bandara, Mr. Ruchira Perera, and Ms. Chiranthi Senanayake for giving us your time. I'm sure all three of you are very, very busy. So you guys have done a very big thing for all the attendees today. All right then. Good night to everyone and have a good day.